OK，差唔多。
Thank you. I think that's about it for the photo taking. Friends of the media, good afternoon. Thank you for coming to the press conference. In a moment, the chief executive will say a few words, and then she will take questions from the floor. As you ask questions, please raise your hands. And if you're asked to ask question, please identify your organization before you put your questions. Now, I'll invite the chief executive to speak. Friends of the media, members of the public, yesterday, the National People's Congress and Committee passed the law of the People's Republic of China on safeguarding national security in the Hong Kong Special Administrative Region. And in accordance with Article 18 of the Basic Law, the Basic Law Committee of the NPCSC was consulted, and the law is now included in Annex 3 to the Basic Law. And in accordance with the decision passed by the NPC earlier, I signed the document to promulgate the law. So starting from last night, you would see that you would have seen the content of the law, and the law comes into effect immediately. I'm sure by now you've had a chance to study the 66 provisions in the national security law. Later on, there'll be a chance for you to ask questions. I, the Secretary for Justice, and the Secretary for Security will try our best to answer your questions. Now, I would just like to briefly say that on this legislative exercise to safeguard national security, in Hong Kong, well, there are two things that really struck me. First of all, this shows that clearly the commitment of the Central People's Government to the implementation of one country, two system, at the same time showed its determination to improve upon the system. Second point is it shows that the high degree of trust of the central authorities in the Hong Kong SAR government. I'll tell you why I came to that impression. Now, since this announcement of piece of national security law at the state level, we've heard much criticism. It's alleged that it is undermining one country, two systems, but that is definitely not the fact. Actually, it's the total opposite. The Central People's Government would like to improve upon the one country, two systems through the national security law, so that the stability and prosperity we've enjoyed in the past 23 years would continue. You might recall last November at the Communist as the Central Plenum, the 19th session is at the Central Plenum of the Communist Party, Chinese Communist Party. It's said that we need to improve upon this one country, two systems. Now, I've been the chief executive for 3 years now, and my view is that one country, two systems is totally unique idea. That's the unprecedented, and because it's so unique and unprecedented in its implementation, there are bound to be problems and issues. So I believe if we are to make sure the one country, two systems work, there is room for improvement, or put more bluntly, in the past 23 years, as we implemented one country, two systems, we did see there are certain inadequacies. First of all, we have not solemnly handled properly the relationship between one country and two systems. You might recall 3 years ago when President Xi Jinping came to Hong Kong, he made an important speech on the 1st of July. He pointed out exactly this point, That is, for one country, two systems, the understanding is that one country is the root, one country is the foundation. So we have to get the foundation and the root right before there's a chance for the two systems to work. So in the past 20 years, or 20 plus years, in terms of our handling of the relationship between one country and two systems, it seems that in the Hong Kong SAR we have not grasped it properly. And the second point is that we have not taken any step to improve the system to safeguard national security. Now, under Article 23 of the Basic Law, we are supposed to enact local legislation on 7 types of crime, but we have not been able to do so. The third point is that we have not been doing a proper job in educating the public, in particular the younger generation, about our history, culture, and so on. And then we have not taken steps to further develop the relationship between the central authorities and the SAR. So there are 4 areas of work where there's room for improvement, and that has led to risk and danger. Now, especially there are people against the government, there are radicals, and there is ideas being spread about going against the government, and that's why things could take a turn for the worse at once. Now, last June we started to see turbulences in Hong Kong, and perhaps that's the reason why. And then since June, well, the Central People's Government has witnessed the turbulences and riots in Hong Kong, and they decided it's time for them to take action. So this piece of legislation shows the determination of the central authorities on 3 fronts. First, the central authorities are determined to see an end to the chaos and riots in the past year. And secondly, the central authorities are determined to protect the majority of law-abiding citizens in Hong Kong. They should be protected from a handful of people who are causing harm and damage. And this is obvious. You can see, starting from June last year, friends around you dare not speak up or speak their mind, and there are businesses there who dare not to work with the government because they're afraid they will be subject to attacks or vigilante attack, or they could be attacked online, and even their family members could be affected. So during this period, many people have lost the freedoms they should enjoy in accordance with the law. The central authorities are determined to make sure that the majority of the citizens here will continue to enjoy the rights and freedoms that they duly enjoy. And third determination, of course, is about implementing one country, two systems resolutely and fully. And that includes the room for improvement that I mentioned. Now, I said that for this piece of legislation, it is to a manifestation of the high degree of trust of the central authorities in Hong Kong. Now, we are talking about a national law. It's about the interests of 1.4 billion people, and that includes, of course, the 7.5 million people in Hong Kong. Now, there are complicated, affairs with the international community, and if you look at this law, you will see that the principal responsible for enforcing the law remains the Hong Kong SAR government. There are a handful of exceptional circumstances or specified circumstances. As I'm sure you'll be interested in asking about those circumstances. Now, apart from this specified circumstances, all the other cases are to be handled by the relevant departments in Hong Kong. For example, with investigation of cases, that's the police force. For prosecution of cases, that's the Department of Justice. As for the trial of cases, that's the independent judiciary of the Hong Kong SAR. Now, apart from this national security law, we'll also rely on the relevant local laws in handling these cases. So to me, I believe it is important that we properly enforce the law because of the high degree of trust the central authorities have in us. So we have to try our very best in enforcing this law. Now, this is a very important piece of law. If we want to enforce it properly, we need to, to have the capacity to do so. And that's why in the national security law, the duties and responsibilities of the Hong Kong SAR government have been clearly spelled out. I'm sure there'll be questions on that. And then there are also provisions on the organizational structure, and that includes the setting up of the Committee for Safeguarding the National Security of the Hong Kong SAR is a high-level committee chaired by me, and it includes the Chief Secretary, Financial Secretary, and Secretary for Justice, and other principal officials. And then there is a National Security Department under the Hong Kong Police Force. It's been set up, but we have not yet announced the person heading this department. And this person would also be a member of the Committee for Safeguarding National Security. And of course, there is the need to have the capability to enforce the law. So the Hong Kong Police Force is empowered by the law to have certain powers and functions. And later on, the Secretary for Security could perhaps tell you a bit more about that. But after all, it's about ultimately, it's about prosecutions without interference by the Secretary for Justice. Now, there's a concept about designated judges. I've explained that concept before on other occasions. The judges are designated by the Chief Executive. The law allows me to consult the Chief Justice of the Court of Final Appeal. And also this designation is just about including judges at various levels of the court in a list of judges. And when a case arises, then it's up to the judiciary to decide which judge will preside over the case. Now, of course, we have the powers, we have the organization structure, we still need funding and the staff or the manpower to do the work. So the law, this law also makes sure that there is the necessary funding. After approval by the Chief Executive, the Financial Secretary will make provisions from the general revenue to provide the funding, and it's not subject to existing laws. Now, this is, after all, in national law. It is about the security of the entire nation. So, therefore, for the SAR government structure that includes the committee that I chair and the various executive arms, we must all keep in close liaison with the relevant central departments, and we have to work very closely together. That's why the central authorities will appoint a national security to sit in on the at meetings of the committee that I chair for providing advice. And there will also be the office to be set up by the CPG in Hong Kong. That is the Office for Safeguarding National Security of the CPG in the Hong Kong SAR. And as I said, there will be a handful of cases under specified circumstances when the central authorities will retain the power to handle these cases. And also the interpretation of the law remains with the NPC. Now, we are entrusted by the central authorities to carry out this very solemn task. We are talking about something that has to do with the well-being of the 1.4 billion people in the country, including the people in Hong Kong. So we will do our level best to make sure we could achieve the objectives of the law. And then hopefully we could improve upon the one country, two system, and then we could enjoy long-term stability. Now, I will ask the Secretary for Justice to tell you something, and then the Secretary for Security will also speak.
Thank you, Chief Executive. In relation to the national security law, I'd like to highlight the major legal issues to you, and I'll take questions afterwards. First, I want to stress that when the decision was made on the 28th of May, it was clearly stated out that to ensure national security and the national interest, and to ensure long-term stability of Hong Kong, and to safeguard the rightful interests of Hong Kong, the law has to be enacted. And in this law, we have to pay particular attention to Part 1, Article 1. And general principles, and that is the basic principles and factors taken into account in enacting the law, and that is to ensure the faithful implementation of the policy of one country, two systems, and to safeguard national security, and to ensure long-term stability and prosperity of Hong Kong, and to protect the lawful rights and interests of the residents of the Hong Kong SAR. And in Articles 2, 3, 4, and 5, I will give you an overview, because they bring out important principles for understanding the application of the national security law. In Article 2, it is clearly stated that the provisions in Articles 1 and 12 of the Basic Law of the Hong Kong SAR on the legal status of the Hong Kong SAR are the fundamental provisions in the Basic Law. And it is stressed that no institution, organization, individual in the region shall contravene these provisions in exercising their rights and freedoms, and that is the provisions in Articles 1 and 12 of the Basic Law. Article 3 of the law states that the CPG has an overarching responsibility for national security affairs relating to the Hong Kong SAR, and it is the duty of the Hong Kong SAR to safeguard national security. These two articles have brought out the very fundamental principles and will facilitate the understanding of the remaining articles. Articles 4 and 5 safeguard the freedom of the rule of law, and also a protection of human rights. Article 4 states very clearly that human rights shall be respected and protected in safeguarding national security in the Hong Kong SAR. The rights and freedoms of Hong Kong people under the provisions of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights as applied to Hong Kong shall be protected, and they include the freedoms of speech, of the press, of publication, of association, of assembly, of possession, of demonstration. Article 5, the principle of the rule of law shall be adhered to in preventing, suppressing, and imposing punishment for offences endangering national security. A person who commits an act which constitutes an offence under law shall be convicted and punished in accordance with the law, and no one shall be convicted and punished for an act which does not constitute an offence and under the law. And there is the presumption of innocence, and a person is entitled to the rights of being represented, and there should be no double jeopardy. And all these can be found in the general principles of the law. And these are very important for us when reading the national security law, so that we know how to understand the articles. And there are things to note in the law. The law itself is unique and groundbreaking in that it contains three special features. First, about the composition and constitution of the structure covering committee, and secondly, it contains a substantive law, one constitutes an offense, and also the penalties. And the third is procedural law. If I may refer you to the law, you can see the constitutional aspect, and that is the formation of an office for safeguarding national security of the CPG in Hong Kong. That is in Chapter 2. And Chapter 3, offences and penalties. And in Chapter 4, you can see the procedural law, and I will brief you on the procedural matters. And Chapter 5, and that is the CPG has the fundamental responsibility to ensure national security. And under that, we will set up the Office for Safeguarding National Security of the CPG in the Hong Kong SAR. Now, the Chief Executive already referred to the procedural aspects. And under Article 14, we have the functions of the Committee for Safeguarding National Security of the Hong Kong SAR. And in Chapter 2, Article 18, the Secretary for Justice shall, or the Department of Justice shall establish a specialized prosecution division responsible for the prosecution of national security-related offenses. We have already set up the relevant division. Details have yet to be announced later, and the relevant personnel are ready to get to work when necessary. All right, as for the substantive law, it can be found in Chapter 3, the 4 categories of offenses and acts. Because the provisions are not that long, I hope we should not summarize it. Rather, I encourage you to read the relevant articles, because the offenses are clearly set out here, and so are the penalties. And you note that there are 3 types of penalties, more serious and not so serious, and minor penalties. Among the 4 categories of crimes, now we are concerned about the ransomers, and it has to be proved before a conviction can be secured. Chapter 4 is the procedural law. Under this part, there are a number of provisions. Article 40 states that the Hong Kong SAR shall have jurisdictions over cases concerning offences under this law, except under the circumstances specified in one article of this law. In Article 45, now the procedures in Hong Kong have to be followed, and so is the mechanism for appeal. And of course, in Chapter 4, there are details on special arrangements, such as the designation of judges, and also the arrangement of a jury, and the SJ can issue a certification in specified circumstances. Of course, this law is for safeguarding national security. There are, of course, bound to be special circumstances. However, in the main, the cases will be tried in arrangements familiar to Hong Kong. Chapter 5 is on Office for Safeguarding National Security of the CPG in the Hong Kong SAR, and it will only take up cases in 3 very rare occasions. So the possibility is low. However, it is the CPG's overarching responsibility to have this authority to exercise when circumstances warrant. Now, the original objective of one country, 2 systems for handover is to safeguard the unity and the sovereignty, territorial integrity, and long-term stability of Hong Kong, as well as the country. So if we have a loophole in our legal system for national security and we do not plug that loophole, then we'll not be able to achieve one very important principle of one country, 2 systems. So we have started a very important step, and that is to set up a safe and sound legal system for ensuring national security and enforcement mechanisms for safeguarding national security. This is a very important objective of the national security law. I would say that this is an important milestone for one country, two systems. Is unprecedented, yet a very important milestone so that we can sail far and steady and to ensure stability of society.
Thank you, Chief Executive. Now, the Hong Kong SL government has to perform its duties under the national security law. The National Security Department was set up today under the Hong Kong Police Force. This is a dedicated department to handle the enforcement of law and the implementation of the law. The National Security Department of the Hong Kong Police Force is the primary department responsible for enforcing the national security law. The SL government has the duty to ensure that the department is able to discharge its functions. So we will provide for sufficient manpower, gear, and training. So staff of the National Security Department are able to discharge their duties effectively. There will be a deputy commissioner heading the National Security Department. We are still identifying a suitable candidate, and that person will be appointed by the chief executive. For other disciplined services, give full support and work and cooperate fully with the police force in enforcing the national security law. The National Security Department is responsible for analyzing and assessing and assessing the situation, investigating the cases, training, and also in coordination work. For the office set up by the CBG in Hong Kong to safeguard national security, its functions also spelled out clearly in the national security law. The office for safeguarding the national security will analyze and assess developments in relation to safeguarding national security in the region, and they will provide opinions and make proposals on major strategies and important policies. The office will also oversee, guide, coordinate with and provide support to the region in the performance of its duties. And then the office will collect and analyze intelligence and information concerning national security, and the office will also handle cases concerning offence endangering national security in accordance with the law. Now, under the national security law, the SL government has the primary responsibility in enforcing the law. So the bulk of the work will be handled and completed by the SL government. The bulk of the cases will also be investigated and prosecuted by the SL government. But under certain circumstances, the SL government may not be able to handle certain cases, or if it's an exceptional case, we have to make sure that these cases could be handled appropriately by the relevant authorities. So the SL government, in particular the Security Bureau, will be actively setting up a liaison and communication mechanism on the discharge to make sure that there is a smooth discharge of functions and duties under the law. After the Committee on National Security and the Office on National Security are set up, then it will be primarily the responsibility of the Secretary Bureau to make sure there's properly liaison. Now, on the 4 types of crimes that endanger national safety, I must stress that for these 4 types of crimes, that is on subversion, secession, terrorist activities, and colluding with security or external forces. Now, there we have primary offences and secondary offences. Now, for the 4 types of primary offences. That is, for those who are the primary offenders, the maximum penalty is life imprisonment. So please do not try to test our bottom line. Don't break the law. And then there are two types of primary offences. Once convicted, there will definitely be an imprisonment sentence. That is, primary offences in relation to terrorist activities. That is, to use threat or use force or threaten with force to say cause a series of violence against a person, explosion, use explosion, arson, dissemination of poisonous or radioactive substances, pathogens of infectious disease or other substances, sabotage of means of transport facilities, electric power or gas facilities, and serious interruption or sabotage or electronic control systems, other dangerous activities that seriously jeopardize public health. The penalty is there is definitely going to be a imprisonment sentence, so people must be aware of that. And also, for people who committed offense of collusion with a foreign country or with foreign external elements to endanger national security, again, there's a minimum sentence of 3 years of imprisonment. But of course, it's for the court to decide on the term of the imprisonment. But anyway, we just want to make sure people fully appreciate the gravity of offences that endanger national security, because all of us has the duty to protect national security. So we must all take very seriously the national security law, and in particular to the offences set out therein. But of course, we will also have to do education and publicity as we promote the explain the, as we implement the national security. Of course, there is the enforcement aspect. There's also the education aspect. So we'll have regard to the actual circumstances, and we will handle the two tasks appropriately. Thank you.
Questions? Please raise your hands, and please identify yourself and the organization before you ask questions. Right? I'm from Now TV. Good afternoon. Now, members of the public want to be law-abiding, but they have to understand the definition of the offences first. There are two controversies. First, that is collusion with a foreign country to incite hatred against the CPG. How do you define hatred? Because, for instance, if you spread messages that there were people who died at the 831 incident at Prince Edward, and second, a serious interference with the operation of organizations. Now, even for the legal sector, now members of the Basic Law and members of the Chief Executive are saying that filibustering or failure to return a chairman for the House do not constitute serious disruption of the operation of government bodies. So can you please clarify? All right, there are already two questions. One more. And also the right to stand in elections. A breach of the national security law will cause disqualification from running in elections, but for how long is not mentioned in the law. Does that mean that once you are convicted, then you'll be deprived of your political rights for life? As for Jay, thank you. Now, Article 22 is about subversion of the state power. Now you have to organize, plan, or commit or participate in following acts by force or threat of force or other unlawful means with a view to supporting the state power. So the intention is to subvert the state power. So seriously interfering, disrupting, or undermining the performance of duties and functions in accordance with law by the body of the Central People's Government. I think you have to take into account the article I just mentioned. As for collusion, now may I draw your attention to Article 29. Article 29 contains two major categories, and for the second, there are also two more limbs. First, a person who steals, spies, obtains of payment, or unlawfully provides state secrets or intelligence concerning national security for a foreign country or an institution. This is the first type. Second, a person who requests a foreign country or an institution, organization, etc., outside the mainland Hong Kong and Macau of the PRC, or conspires with a foreign country or an institution, organization, and the third is to directly or indirectly receive instructions, control funding, or other kinds of support from a foreign country, etc. So it's not just as simple as inciting hatred. You have take the whole article as a whole. So if you steals or spies such items on behalf of a foreign country, then if you do this, then you will be caught for collusion with a foreign country or external forces. And does that constitute hatred? We cannot just look at one single act. We have to consider in total the speech and also the acts and take everything into context before we can come to a conclusion. And the other question relates to Article 35. Under Article 35, a person would be disqualified from standing as a candidate in certain elections. We have to bear in mind that the four categories of crimes are serious offenses. That being the case, Article 35 doesn't specify the length of disqualification. So you can consider disqualification for life. Now, you have to bear in mind that we're talking about secession, subversion of state power, terrorist activities, collusion with foreign or external forces to endanger national security. All these criminal acts would endanger national security. So we have to consider that we talk about very serious offenses leading to this punishment. Next question. The reporter in front. I'm from Hong Kong 01. I've got 3 questions. Article 50 says that personnel of the officers of SNS have to be law-abiding. And Article 60 says that when they are carrying out duties under this law, they are not subject to the jurisdiction of Hong Kong SAR. Does that mean that staff of Office for Safeguarding National Security will be beyond the control of law, and under what circumstances will they be not subject to the jurisdictions of Hong Kong SAR? And as for disqualification, now come the September elections for the legislative election, does that mean that if anyone who openly objects to the national security law will be disqualified from running? And it said that it is against the law to disrupt anyone, to disrupt government body from discharging its duties will be against the law. How do you define such an act? All right. I'm sure you will put to us scenarios and ask us to say whether it is against the law or not. I'm sure you understand that whether an act is unlawful cannot be simply described here and then we have to tell you whether it is against the law or not. We have to consider the legislative intent and also the interpretation of the law first. This is just a footnote. I don't want to be as simple as to tell you whether it is against the law or not. Regarding the staff of Office for Safeguarding National Security of the CPG, the SJ will supplement later. Now, on the right to stand in elections, as we all know, in our election related legislation, the qualification to stand an election is very clear. And we have the electoral officer to decide whether someone is eligible to stand, and then a prospective candidate has to make a declaration that he will uphold the basic law and pledge allegiance to the Hong Kong SAR. And then the returning officer will decide whether he is qualified to run or not. So I cannot simply say here whether he will lose his qualification by making certain remarks or doing certain acts. The most important thing is to adhere to the law. I will see whether the SJ can give us a general response to the other two questions.
On Articles 50 and 60, they are actually complementary. Article 50, there is an important point. If it's not just about observing the laws of Hong Kong as well as the national laws. So this stated clearly. And then for Article 60, is stated that if the office performs its functions in accordance with the law, with this law, and then it's not subject to the jurisdiction. So I think the key considerations about Article 50 on whether the office is acting in accordance with law. Next, please, to the far left. I'm from the Central CTV. Now, the MPC actually chose to pass the national security law on the eve of the 24th anniversary of Hong Kong's reunification with Netherlands. So how would it help Hong Kong's future development? And you say the law is to further improve upon the one country, two systems. Can explain the details. And a third question. Now, you're going to set up a committee for safeguarding national security of the Hong Kong SAR. So how will the chief executive lead this community to make sure Hong Kong plays a more effective role in safeguarding national security? So there are three questions. First, I don't believe this task is aligned with the anniversary of the reunification, but rather there is an urgency in enacting the law. We have seen the turbulences and riots in Hong Kong in the past year. We've seen the involvement of foreign forces, and we've seen local politicians requesting interference from foreign countries and foreign governments who were happy to interfere. Some country has actually enacted its own legislation, is also threatened to sanction the country and Hong Kong. So perhaps we can put it this way: the central authorities could not put up with this anymore. So there's a determination to do something. Now, this legislative process is at the highest level. First is the National People's Congress that made a decision to authorize the Standing Committee of the MPC to enact and to draft and pass this law. And then, in accordance with Article 18 of the Basic Law, this law is to be included in Annex 3 for implementation in Hong Kong. So there is a stringent process that was followed. And it was yesterday, the 30th of June 2020, the law was passed. Now, there are many advantages for the future development of Hong Kong with the enactment of this law. First of all, the central authorities and Hong Kong as a government, we have faced immense challenges, but still we firmly believe that one country systems is the best system to ensure the long-term stability and prosperity of Hong Kong. But there is a need to improve upon the system. So at this point in time, there is an important aspect that needs to be improved upon, that's national security. So we need to take actions to do that. This is to make sure that we could, sail far and steady. Secondly, with the passing of this law, we believe there is a chance for Hong Kong to return to stability Well, I say there's a chance because we've heard there are some who pledge they will continue with their fight, but that does not matter because now we have the law. We will firmly enforce the law. But if we could go back to stability and peace from the virus experience, that would make a huge difference. We've all seen how our economy has been affected. Now, if there is stability restored, that is good news to the 7+ million people in Hong Kong. Of course, the SF government will also take various steps to stimulate the economy and improve people's livelihood. The third point is that the law is an opportunity for us to better publicize the constitutional order so people get to know about it better. And then it's a matter of what we'll do in support of that effort. Now, law enforcement, of course, is very important, but that's not all of it. If you look at the Chapter 1 of the National Security Law, that is, we need to have enforcement mechanisms to deal with the 4 types of crimes. There are at least 2 other articles in Chapter 1 that say that we have do proper publicity, give proper guidance, and do oversight and so on. This is make sure that schools and other bodies in Hong Kong will all come to fully understand the law. And this morning in my speech, I said, okay, now we have enacted law and we have the capabilities to enforce the law. But if we want everyone in Hong Kong to embrace or to safeguard national security, there is still a large amount of publicity work that we have to do. And of course, that is our duty too. And then for other aspects, as the Secretary for Security said, we would support the law enforcement agency, that is the police one in particular, to set up a national security department to carry out the work. Third question, we are grateful to the central authorities for the high level of trust put in us. So we will set up a committee for safeguarding national security of the Hong Kong SAR. As I said, this is a very high-level committee. As the chair of the committee, will make sure that we will discharge our duties properly in implementing the national security law. And then on how we are going to what we do every year to safeguard national security. The chief executive is required by the law to submit an annual report. So as the chief executive, I of course am answerable to the people of Hong Kong. I'm also answerable to the central authorities. So I have to submit a report to see what we've been doing and identify room for improvement, and that is squarely the duty of the chief executive. Thank you.
Any on that side? The lady at the back, please.
Hi, this is Lillian of South China Morning Post. First question for Mrs. Lam. So according to the new law, you got the power to allow phone interception or surveillance, and you can even issue warrant. How could you respond to critics that you are not overriding judiciary power or infringing human rights? And what will you do if there's conflict of interest? And to what extent your failure in governance, including the failure to introduce local legislation on the implementation of Article 23, have forced the central government to impose this security law? Are you somehow remorseful for your failure and harm for Hong Kong? And a question for SJ. So you're one of those sitting in the National Security Commission. How can you make sure you can uphold fairness and not to be interfered when you make prosecution decision, especially when there might be discussions in the commission? And on some serious cases, a suspect could be handed back to the mainland. Does it mean he will then be tried by the Chinese law and might reach death penalty? And my last question for Mr. Lee. So police has been already arresting people using the new law, while your organization are still setting up and is still finding the chair. So are you going to take forward these cases since the public may not be familiar with the new law? And in general, do the 48 hours of detention period still apply to these cases? And because it's not mentioned in the law. Thank you.
Well, I think there are a lot of questions for the three of us to address, so I will confine myself to the first set of questions. Now, first of all, yes, as you have noticed, under Article 43, where we refer to additional measures for the police to take in order to investigate into cases of offenses under this law, and by the way, as the Secretary for Justice has emphasized, this law prohibits very, very serious offenses. And as the Secretary for Security has explained, because of the severity of the offenses, they attract very heavy penalties. So this is the starting position of our discussion on the individual articles in this piece of ordinance. Yes, under Article 43, there is a power given to the Chief Executive to authorize interception of communication and surveillance by the Hong Kong police force. Yes, this is a very important power given to the executive. But as I said, this is because we are dealing with very serious offenses. And the chief executive, as I repeatedly said, he or she has accountability and responsibility to the Hong Kong Special Administrative Region and also to the Central People's Government. And we have been entrusted with the responsibility to implement a piece of law which safeguards not only Hong Kong people's interests, but the 1.4 billion mainland Chinese interest. So to have this power is very important and effective for us to ensure that we could discharge our function. I do not see how this executive power of the chief executive undermines the independence of the judiciary. They are entirely two separate matters. The judiciary will continue to adjudicate and conduct trials in accordance with the very important legal principles, including the independence of the judiciary, which we all embraced and put a lot of significance to. You also mentioned about human rights. Yes, this piece of law has said at the very beginning that we will safeguard human rights as provided for under the Basic Law and the two international covenants on human rights. But if you go through the two international covenants, for example, the ICCPR, it does clearly specify that some of the rights to be exercised by the individuals could be restrained or regulated by law if it is for the purpose of protection of national security. You also mentioned about conflict of interest. I don't see what sort of conflict of interest I will have in protecting national security in Hong Kong and for the country. My only duty and commitment as a chief executive is to serve the country and serve the people of Hong Kong. Now, finally, about the relationship between this piece of national security law and Basic Law 23. Yes, we have been deploying this explanation that somebody said, we have been waiting for 23 years that Hong Kong SAR still could not enact local legislation to prohibit the 7 types of offenses that will undermine national security under Article 23. So this is a time for some resolute action. But Article 23 will continue to be effective. The government of the day will still have to enact local legislation on Basic Law Article 23, and this is clearly stated in Article 7. In Article 7, in this piece of national security legislation, and also in the decision passed by the National People's Congress on the 28th of May. So I wouldn't say that it is entirely because there isn't a Basic Law 23 that there is now this national security law, and one should not jump to the conclusion that if we have Basic Law 23, then we don't need this law. We have included, I think, an explanation in this booklet that even if Article 23 were to be enacted in a future day, the national security law now passed by the NPCSC, together with the local legislation passed by the Hong Kong Legislative Council, will together form the complete regime for protecting national security in Hong Kong. Secretary for Justice.
Let me supplement the Chief Executive in regard to your question about executive authorization in relation to interception communications. First of all, many countries around the world, including Western countries, they have executive authorizations to intercept communications in relation to protection of national security. This is not new. They are doing it. So we now, because we have this new law, we have to discharge this function and duty. So it is necessary that we have a regime to take care of this matter. Obviously, different countries will have different ways to ensure sufficient safeguards are given. This is what we will be doing. What the law does say is, first of all, this has to be prescribed by law. Second thing is there should be sufficient safeguards. We will be looking at this method of executive authorization to satisfy those requirements. The second thing is we have to appreciate that in relation to national security matters, the targets that we are dealing with are likely to be of a state-level opponent. Their abilities, their methods, and their experience in this regard is something that we must take good care of in order to ensure that we can sufficiently discharge our duty. In regard to your other question about arrests having been made by the police, when the law is promulgated, it becomes effective law in Hong Kong. When it becomes effective law in Hong Kong, everybody has to abide by it. That is always the laws of Hong Kong. That is what the basic law says, and I think that should be our common sense and common knowledge. We will do education, but something that has been so outrageously broken the Hong Kong law, then the police has a duty to take action. We have established this new department to deal with this piece of new legislation. The police will handle it in accordance with the law. In regard to the detention, there is no provision in this national security law to change the procedure or law regarding detention. So we will handle it in the way as it is stated in the present law.
Thank you. Shall I answer the question very quickly, please? Now, the fact that I'm on the National Security Commission, if we'll call that at the moment, would not in any way interfere with my discharge of the role as the head of the Department of Justice under Basic Law Article 63. What is important when one is to understand the independence of prosecutorial decisions is that Article 63 explicitly say that the Department of Justice is to control the prosecutorial decisions, conduct of the matters, etc., free from any interference. And therefore, anyone who attempts to, quote unquote, interfere or say specifically, forget about the evidence and just proceed to prosecute, of course, that would not be listened to. Any decisions that the Department of Justice is going to make in relation to prosecutorial decision will, as always, be based on fact and evidence. And the fact and evidence is something that will be provided to us through the law enforcement agencies, in particular in here, the special branch set up under the police force. And that will allow us to make the decisions independently, free from any interference. You've also mentioned in your questions about the situation regarding effectively the triggering or the carve-out part of the legislation which is within the jurisdiction of the central authorities. Insofar as that is concerned, that of course is already carved out and therefore no longer something that is within the jurisdiction of Hong Kong, and therefore how that is to be dealt with will be something that will not be within the purview that we will be able to interfere in that sense. All right.
Take one more English question. Okay, please.
Hi there, my name is Ivan Watson. I'm a reporter with CNN. Two questions for you. First, under this new law, is it legal or a crime to criticize the national security law? Second, you have repeatedly said that it will be a tiny minority of people who could be prosecuted and targeted by this law. The police have already arrested one person, they've announced that, for violating the new law. Are you anticipating dozens of people being prosecuted? Hundreds? Thousands? Which would still, arguably, statistically, be a tiny minority?
Well, to answer your second question first, I would rather not to be able to, not to arrest or prosecute anybody if everybody abides by the law. The purpose of this piece of legislation is not just to punish, it is also to deter people from committing such serious offenses as secession, subverting the state power, terrorist activities, and so on and so on. So deterrence is very important, and that's why the Secretary for Security has spent some time in his introductory remarks to highlight the penalty under this particular piece of law. So, but I still believe that the great majority of Hong Kong people are law-abiding citizens. They love the country, they love Hong Kong, they want to have stability and prosperity, especially at a time when we are affected by COVID-19. This becomes even more important to have stability for us to relaunch our economy and to preserve and create jobs for the people of Hong Kong. Now, criticism, it comes under freedom of speech. There is a specific reference in the principle of this piece of law under the General Principles, Chapter 1, Article 4, which provides for the Hong Kong SAR to safeguard national security, which should also safeguard human rights and so on, in accordance with the Basic Law and the two international covenants, as far as the relevant provisions that are applied to Hong Kong. But as I have just answered one question already, all these, or some of these human rights enjoyed by individuals under the international covenants are not absolute, as the covenant provisions specify. Where it is for the protection of national security, then sometimes some of these rights could be restrained in accordance with the law. Now, but it is clearly stated in Article 4 that people of Hong Kong, they should be able to continue to enjoy the freedom of speech, freedom of press, of publications, protests, assembly, and so on and so on. So if individuals, including reporters from CNN, they are discharging their role and they feel that something is not right, they want to criticize, I don't see why that will become an offense under this piece of law. But of course, if there are more behind it, if you are involved in organizing or colluding and so on, then it's another matter. But at the end of the day, it's a question of evidence and the law.
Well, I would like to add in regard to your question about number. It has been for 23 years that we have a vacuum in relation to protection of national security. It has been a vacuum in the law to tackle people who advocate independence. We will make it a small number, as small as possible. We have this law a long time ago. This is a time when we make this change. I have said that the law actually asks us to also do education. With education, with prevention, and with enforcement, we can turn the tide to let people know that protection of national security is everybody's responsibility. That advocacy for independence of Hong Kong is against the law. That will make the number small. And it's time that we act now so that that number is capped to the minimum. We want to see a zero number at the end of the day. That is what we are now doing. We should all work together to educate people, to make them realize that if we love this place, then protection of national security is an important thing for us all to do so that the number will be the smallest. And eventually, we hope that we don't see any number that need to be dealt with under this law.
下一條問題，左這邊近中。
Next question, please. The one in blue. I'm from Hong Kong, RTHK. Good afternoon. First, on enforcement. Article 43, 7, it says that for people who have for whom there's reasonable suspicion that they can possess certain information, they could be asked to produce the information. So does it mean it could be journalistic material? And could there be any defense from the journalists involved? Now, the police has arrested 30 persons in Causeway Bay, saying that they have violated the national security law because they chanted slogans of Hong Kong independence. What about, liberating Hong Kong or the 5 demands, not one less? Are these slogans allowed? Now, if the government believes that these slogans will incite hatred against the government, then it will be ruled unlawful. And many medicines asked that, in the past year we have many social disputes, and there's the anti-extradition law, and there's also epidemic. But what have people in Hong Kong done wrong? Many asked. Now, the national security law was promulgated within your term, so what do you think about that? I'll take the third question, and I'll ask the Secretary for Security to take your first question, and then the Secretary for Justice could take your second question. Now, this morning at the reception to celebrate the 23rd anniversary of the reunification, I said that this is a historic event, the celebration that is, because in June 1st, there's the passage of the national anthem law in Hong Kong, and then yesterday the NPC Standing Committee passed the law for safeguarding national security in Hong Kong, and then law was promulgated in Hong Kong for implementation. So these are 2 important pieces of legislation to do with one country, 2 systems. And these 2 laws are passed in my term. In fact, they passed within 1 month, and I am happy to see that. And I am grateful to those involved who make this possible. Now, in Legislative Council, this is just a straightforward piece of legislation on respecting national anthem, but it took 18 months in Legislative Council for the law to be passed. And then we've seen all sorts of acts that we wouldn't want to see in LESCO. That's even, insulting acts against the Legislative Council. Now, we all know why there was a need to legislate for protecting national anthem, because people of what happened in the past. And then we've seen legislators who declared openly that they tried to stall the election of the chairman for the House Committee just because they wanted to stall the national anthem legislation. So it's something they said, we didn't make it up. Now, I said already that there's a problem with what's going on in Hong Kong, and you say I said so. Yes, it's true. I am responsible for that. Many people are responsible for that. It's like when we're parents, if we want to teach our children properly, if we know there's something we don't do well, we try to improve that. And here we're talking about 2 pieces of legislation. It's important that we enforce them properly, because that will help to improve the implementation of one country, 2 systems. So there will be full and faithful implementation of the system, and that's what I think. Now, your question was about Article 47 or 43(7), 43(7). That is where there is a reasonable ground of suspicion, a person could be required to provide information. Here, I think this provision has to do with the 4 types of crimes. And these 4 types of crimes are serious offenses. That's why we could invoke existing legislation such as the Organized and Serious Crime Ordinance. And then we could ask suspects to furnish information or answer questions. So there is this power. In short, under the Organized and Serious Crimes Ordinance, the police could, after securing approval from the Secretary for Justice, apply for court warrant or court orders on witnesses and so on. So here, Article 43, bracket 7, is just to extend that power to the 4 types of crimes under the national security law. So that's actually an extension of an existing power. Because there are 4 types of serious crimes here. They are serious crimes, and you see the penalties are heavy. So it just makes sense for that power to be extended to these new 4 types of crimes. And then second question about different types of different acts and types of behavior that happens in Hong Kong. Now, I think the most important principle is for the police officer enforcing law, if he or she believes reasonably that that person is acting in a way that violates the national security law, then the police officer could take action accordingly. The police officer could arrest the person, investigate into the case, and collect evidence. And if there is sufficient evidence, then prosecution could be taken out. For the new 4 types of crimes, I don't need to repeat them because the law has been gazetted and it's come into force. Now, in deciding whether the act is against constitutes an offense under this law, the law enforcing officers will have to go by their experience and training, and they will take actions as required by the law accordingly. Now, the reporter asked about people arrested. Now, after these people arrested, the law enforcement agency will, of course, try to collect evidence, and then they will submit a file to the Department of Justice, and then we'll look at the evidence, we'll look at the relevant law and our prosecution code, and then we will decide whether to prosecute or not. So it's just the usual mechanism. Now, you mentioned the chanting of slogans. Well, we can't just decide whether a person is committing an offense or not just based on the chanting of a slogan, because when we decide whether someone has committed offense, we don't just look at one single element, we look at the context. So we need to look at the act, we have to look at the context, and then we have to determine the mens rea to see whether it could be established. For example, by chanting a slogan, would it could it constitute an interpretation that is an act to subvert this power of, or if for a slogan being chanted, if people would understand that as advocating independence, then we really have to look at the mens rea, and then we have to look at it in context.
Next, the lady in front, on the right. I'm from TVB, Mr. John Lee. When it comes to collection of intelligence, there can be production of a search warrants and interception of communications and so forth. What types of crimes and to what extent will you use such powers? And under specified circumstances, the Office for Safeguarding National Security of the CPG will exercise jurisdiction. What are the circumstances under which the Hong Kong SL cannot take care of? And will it be for the office to decide whether it will exercise jurisdiction or for the Hong Kong SL to put a request to it? With regard to interception of communications, under the national security law, Article 43(6) says that upon approval of the chief executive, that we can carry out interception of communications. Now, many Western countries are already doing that. When it comes to national security, interception of communications will be authorized by the executive, and for it to happen. Under this law, the chief executive is allowed under the law to give approval to do this. Of course, we are talking about circumstances where the four categories of crimes in this law have been committed or are being committed. To prevent the commission of the four categories of crimes in this national law, then it can be a ground for us to apply for approval from the chief executive. And then Article 55 is, I think, a very, very rare situation. Now, let's use some imagination. Now, you are watching a movie, and if I feel that we're being infiltrated, so that we have lost confidence in our law enforcement agencies, then perhaps this is something beyond that is something we cannot handle. So I think this is a very rare and unusual situation, and it's unlikely. However, we have to tackle some units that are in espionage and in infiltration work. They are very experienced, and we've seen them in history. And sometimes we've seen that reported in the news. They can do things, they can infiltrate our government in ways you cannot imagine, so we have to be highly vigilant. Let me supplement. When it comes to Article 55, the specified circumstances, now there are three, one of which, well, if one of it is satisfied, then Article 55 can apply. However, there are procedures. Now, the SL government can make such a request, and the Office for Safeguarding National Security of the CPG in Hong Kong SL can also raise it to the CPG for approval. That means, well, even I, as the head of the Hong Kong SAR, cannot say that, well, the situation warrants passing the jurisdiction to the office. And there's no question for the Office for Safeguarding National Security to exercise jurisdiction on its own. He has to seek the approval of the CPG first. So this is a safeguard. Now, I know that this is a sensitive issue which you will for sure ask about. Well, under Article 4, in this book, question number 4 has cited some examples. Of course, we have some communication with the CPG. Under what circumstances the scenario will arise? For instance, when foreign organizations infiltrate into our organization, or defense or diplomacy is involved, and the SL government's ability alone cannot investigate and deal with the scenario. Now we are talking about national security. This is not just something for the Hong Kong SL. There is also the very complex relations at the international level. So there may be things which is beyond our ability to handle. And then in scenario 3, when a major and imminent threat to national security has occurred, of course you ask what is meant by a major and imminent threat. And it will be hard for me to make an objective definition. But if we have put it to the CPG, and it's also confirmed that the jurisdiction has to be handed over to the Office for Safeguarding National Security, then this will avoid the situation under Article 18(4) of the Basic Law in the event that the SC of the NPC decides to declare a state of war or in a state of emergency. The Central People's Government may issue an order applying the relevant national laws in the region. Now, if you could envisage or preempt this situation, then we can exercise Article 55 so that we don't have to invoke Article 18(4) of the Basic Law, which will be a more serious situation. Mr. John Lee said that it would be a very unlikely and rare situation. I also used a similar description, but I think the CPG has to play safe, 100% safe. However, I'm of the view that this scenario is very, very unlikely to happen. I'd like to supplement. Now, for Article 43, we have to note the preamble, and that is, when handling cases concerning offense endangering national security, the Department for Safeguarding National Security of the Police Force of the Hong Kong SAR may take measures that law enforcement authorities, etc., may also take the following measures. So we have to note the preamble.
The last question. I'm from the Economic Journal. Good afternoon. The Secretary for Justice gave an explanation on Article 60 for staff of the CPG office in Hong Kong. Now, whether they should comply with the law of Hong Kong, it depends on Article 50. Now, Article 60 says they are not subject to the jurisdiction of the Hong Kong SAR. If someone believes that when the office staff do not comply with the laws of Hong Kong, then if the Hong Kong SAR has no jurisdiction, then who has? Second question is about Article 4. It lists out the human rights and freedoms enjoyed by people of Hong Kong. But then Article 14 says that the decisions made by the committee for safeguarding national security is not subject to judicial review. What if some people believe that their rights or freedoms are affected, and how can they seek redress if where is the redress mechanism if there's no judicial review? Now the committee led by the CE is still a committee under the Hong Kong SAR government. How come it can override the courts here? Article 50. It says that the office shall perform its mandate in strict compliance with law and be subject to supervision in accordance with law. It shall not infringe upon the lawful rights and interests of any individual or organization, and that the staff of the office shall abide by the laws of the Hong Kong SAR as well as national laws. And then the staff of the office shall be subject to the supervision of the national supervisory authorities in accordance with the law. I hope you will understand it this way, that is how the office is subject to supervision. As for this is a national law. You must bear this in mind. This is a national law enacted by the NPC Standing Committee, and this national law is included in Annex 3 to the Basic Law, and then there's a promulgation for this law to be implemented in Hong Kong. So we have to understand it this way in how this law operates. As for protection of human rights and freedoms, we have to first understand how about the operation of the law, and then let's say when we take up prosecution, we have to make sure whether these the relevant principles are breached. And it's not about the decisions made by the committee. Now, the committee makes decisions on policy matters, And this is a committee safeguarding national security led by the Chief Executive of Hong Kong. So the committee may make policies in relation to national security, and we kept saying this from the outset. National security is a responsibility of the central authorities. So here we are talking about the work of the committee, which is not amenable to judicial review. But then when it comes to law enforcement, well, maybe it's not just it's not necessarily judicial review, but definitely we have to go through the relevant judicial process when we enforce the law. So we have to note the nature of this law and the objective of the law. And then we also have to note the different work done by different departments. Thank you. That's the end of the press conference.